this on? You got the green light?
Mhm.
Yep, looks like
Yep.
you're good. Okay. Good evening, everybody. Thank you for joining us here for another edition of STEPP, Stabilizing Tenancy Eviction Prevention Program. So I am joined here with Sarah Webb from Community Health Law Project. We're going to go ahead and introduce her in just a moment. I'm going to go ahead and share the screen as I typically do during the course of our STEPP series here. So I'll go ahead and get that, guys. We'll go ahead and start a slideshow so that you can follow along with the content and enjoy, the material as we go through it today. So again, thank you for joining us this evening. This is STEPP, Stabilizing Tenancy Eviction Prevention Program. So just want to take a brief moment to, once again, thank you for joining us, but just kind of let you know, for those of you who are newcomers and enjoying this program for the first time, what STEPP is. Again, STEPP is an acronym. This is not a dance class. It is what is referred to as Stabilizing Tenancy Eviction Prevention Program. So what does that mean? So basically, in social services, we love our acronyms. So our grant funding, the offices we deal with, everybody, they all have acronyms, different names. So STEEP or STEPP, Stabilizing Tenancy Eviction Prevention Program. So it's just a landlord-tenant series. It's a seminar, module, classes, presentations, if you will, that have been allowed for our agency to proceed with. We've been funded by the New Jersey State Bar Foundation. So the New Jersey State Bar Foundation earlier in the year had submitted proposals to the public, to nonprofit agencies and other organizations alike, to get their hands on some grant money. And one of the ideas that Family Promise of Sussex County came up with was to have a landlord-tenant seminar series geared towards, with the objective being to develop more peaceable, more civil, more informed, educated, and less litigious landlord-tenant transactions. So this is for everybody. This isn't just for prospective clients, because as you know, at Family Promise of Sussex County, our motto being that everyone deserves a home, we work largely with the population in a prevention sense. So diverting eviction, people who need rental arrears paid, or for folks who are dealing with the street level homelessness. That is what our organization does. But this program is not just simply for those particular clients or prospective clients. Rather, this is for everybody. So we're inviting the entire community. So landlords, tenants, area legal practitioners, service providers, people who just want to be part of the solution. Again, with the idea of developing a better transactional society when it comes to landlord-tenant relationships. So, and if you do find yourself in the situation where your circumstances do become litigated, we want to arm you with the best information that you have that is possible. So again, want to take this opportunity to thank the New Jersey State Bar Foundation for their generous grant opportunity that allows us to develop these presentations, invite lovely guest speakers like Ms. Webb to come and join us and present to you some really wonderful information. So that's what we're doing here today. But as we go forward, what I do want to do first is just let you know that although this is legal information that we're presenting, it is informational in nature. So Family Promise of Sussex County itself is not a legal service provider. We defer any advice that you may need to our colleagues at Legal Services of Northwest Jersey. We cannot legally provide you with advice. So if you do have anybody in the comment section, so who's joining us over the live stream, for anybody who does have questions that are of legal consequence, I myself, being a representative and employee of Family Promise of Sussex County, cannot provide you with that particular answer. We do have Miss Webb here. She actually is a licensed bar attorney. So she's the real deal. So she may be able to help you in that regard. But just as a general blanket statement, as it pertains to Family Promise of Sussex County, we just want to let you know that, if I myself, if a question is given to me, I just want to let you know I'm not being rude or disregarding your question. I'm legally bound to defer to a licensed bar attorney for that particular matter. But of course, again, I'm joined by Sarah. So again, we appreciate you coming out here. She's joining us. Came all the way up from Elizabeth, New Jersey, to and bared the braved the traffic and is here to join us and enlighten us with some of her information. So just briefly. Just review the timeline here. Again, this is an instructional course. We do provide information about landlord-tenant related matters. So today's October 1st is our first class of the month. We are doing rent increases. So if you follow the timeline of our curriculum, our kickoff class was housing discrimination. We did familiarizing yourself with the law. A court services officer from Morris County Superior Court, Christopher Whitten, joined us for that class. Renting your new home was September 24th. And then, of course, today's rent increases. Next week, the 8th, we'll be doing habitability. And I believe we'll be joined by Randy Yang of Legal Services. So we're happy to have Mr. Yang join us as well. We've got a lot of really great people coming from Legal Services of Northwest Jersey to join us and present this information as well. So again, thank you to all our guests and again to Ms. Webb for joining us for this series. So appreciate the time and the information that you're able to dedicate to our audience. So moving forward, now, again, I am not an attorney. You might be asking yourself, then why am I presenting this legal information to you? So just to let you know a little bit about myself, I am the programs manager here at Family Promise of Sussex County. Ms. Webb is the managing attorney at Community Health Law Project, and she's going to get into a little bit about what she does at that particular agency. Here, I entered this agency. What's called a program was called CEDD, or Comprehensive Eviction Defense and Diversion. That was a program that was awarded a grant that came from the Department of Community Affairs Office of Eviction Prevention. They gave us a generous grant opportunity to go to court as social service providers. But we would work with legal service providers, court staff, landlords, tenants, private attorneys, litigants, anybody to resolve the issue. Think outside the box. If it was paying the rental arrears, or if it was finding the underlying cause for why someone fell behind with their rental arrears, if there were services within the community that we could help resolve the underlying issue, we were essentially bridging the gap between the courtroom and the services in the county, including those services provided by Family Promise of Sussex County. But in the course of operating that grant, I learned a lot about landlord-tenant law and made a lot of connections with some really wonderful professionals. So we thought it'd be a great idea to use that as an opportunity to develop this platform and present to you tonight with STEPP. And of course, we're doing rent increases this evening. So now that's about me. I thought I'd turn it over to Ms. Webb, if you want to share a little bit about what you do and how you came to be involved with us tonight.
Yeah. So my name is Sarah. I'm with Community Health Law Project. I'm based in Elizabeth, New Jersey, but our office is a statewide legal services organization that specifically serves people with mental health disabilities, other disabilities, and chronic health conditions. Some of our offices also serve seniors, including my own in Union County. But we have a couple of regional offices throughout the state, one in Bloomfield that actually serves some Sussex County folks as well. Okay. So, but we have a disability focus. And I am here because I met Frank as part of the SED program, and we're working with this great partnership with DCA as well to provide legal services to people facing eviction. Mm-hmm. And I've been, in legal services for a number of years. And I got into this work just because I really do believe, like Family Promise does, that everybody really deserves a home, really a stable place to live, and increasingly in New Jersey, it's hard to find affordable housing. So what we do to prevent eviction is really, I really truly believe strongly in it, and we're really happy to be part of this education series because the more you know, it's really critical for tenants and landlords to understand what their rights are and what their obligations are. So Thank you for having us.
Thank you, Sarah. We greatly appreciate that. So when you talk about Community Health Law Project and the regional offices and people who have handicaps or disabilities, is that documented, like they receive benefits? Like, is it physical disabilities? Is it anybody who receives SSI, SSDI? How does that process work?
So it depends. Like as you know, we have a couple of different contracts to serve folks with varying different types of disabilities. In our Bloomfield office, they have an array of contracts. And if you call, if you have a disability, you're facing eviction, you call our Bloomfield office, they can assess. But we do a lot of folks that work with Northwest New Jersey Legal Services are often, they sometimes will go to our office, and we have that same kind of relationship as we're kind of like a sister of legal services throughout the state and serving with a disability focus. So, but we do a lot of work with people living with mental health disabilities.
Okay, that's good to know.
But we don't have a particular way we assess. We don't like double check people's health records or anything. They just kind of self-identify to
That's
us.
good to know.
Yeah.
That's good to know. So it
Exactly.
almost feels like it's low barrier in that regard.
Definitely,
Okay,
definitely.
that's good. That's
Exactly.
good. Because in my own experience, I can even recall collaborating with Community Health Law Project with cases that I've worked where we felt that there was a shortcoming in terms of the representation that we had here in our field. Because again, we don't have the credentials to represent somebody in a legal capacity like y'all do. So it was really nice to connect with CHLP. And what was really great in this particular instance is the staff attorney that I worked with was able to identify like procedural or constitutional deficiencies with the complaint, which was really clever because we needed more time to come up with the funding. There was a significant amount of arrears that were owed. I was trying to pool from a coalition of collaborating agencies. So I had to get from all, promissory letters from all the different area providers. And it was just a lengthy process. So getting that legal, acumen and being able to have someone point out and say, oh, actually, they weren't properly served with process, which they were able to get the case dismissed, which bought us more time, was really significant. And I can, personally testify to the collaborative, benefits of that, that service. It's really wonderful what you guys do.
Definitely, definitely. And I think interesting what you say, like as part of this education series, I think people will find out as you go along that landlords do have to meet a lot of technical requirements as they assert their, as they go through an eviction or a rent increase, for example, as we'll talk today. So some of these procedural issues, they can really, the landlords have to follow the law, and when they don't, we may have some leverage to get more time, even, even if the rent is owed. So I'm glad you had that experience.
Yeah. Any like little bit can help. I just want to make sure. Oh, there's no video. So let's see. I'm glad I'm getting text messages from people. Stop sharing for a moment.
Well, good. I can fix my hair while we're doing this.
So, I mean, there's video here. I know there's volume. There's voice. So I'm just going to go ahead and keep this here. I'm going to share my screen. And let me just actually do a little experiment here. I do apologize that we're doing this in the we are doing this live. So actually, let me see. I stop the share. Let's see. And that's okay. Oops. Go to window.
I guess your producer didn't come in and
No,
popped out for the night, huh?
we didn't have that available.
This
so
is
it's just
homegrown.
me. So let me actually, so we'll close this out for a second. I do apologize, folks. We're gonna get this back up and running in just a sec. So I'm gonna say, go ahead and save. Let's close this out. Oops. Say don't save so I can close it out. And then I'll reopen. And we'll do PowerPoint. So that's here in the window. And if it doesn't pull up, we'll just keep rolling with what we got. Got to do what we got to do. And I will try my best to describe what is on our end for the folks who have tuned in to enjoy our conversation. But that's what you're for too. So even if there is a visual component that is missing, I'm glad that you guys still get to hear us and you get to hear and enjoy our conversation. And you'll still get to get all of the wonderful information that is presented here. So hopefully this time around, I'll go ahead and see. Let's cancel that. And let's go ahead and try to share again. Go to window, PowerPoint, share, and hopefully it works. And if not, hopefully you guys are getting the PowerPoint presentation. So I'm gonna go to slideshow from current slide. Perfect. and we'll just keep going through. But thank you for letting me know that the video wasn't available. But again, I'm running the show on my own tonight. I do apologize
That's
for the
good.
tech shortcomings. Let me just double check, make sure you got the green light on your mic. So
Yep,
we
we're
still
good.
got sound. So you know what? We're still conveying the information. I'm glad we still sound here. So as we're going through, so hopefully everybody has an opportunity to see at least the slides. I don't know if you can, and I do apologize. I'm using a Surface Pro, so sometimes the Surface Pro is a little finicky, and it can, just be, sometimes the camera works, sometimes the mics work, sometimes. But we're just going to roll with it tonight. And Sarah, I appreciate your patience as
Not
well
a
as we're working out the
problem.
kinks. And thank you to informing me that that was an issue. But like I said, we're going to roll with it and just enjoy. So this might just be a sound presentation, a sonic presentation tonight, but you'll enjoy it just as much, I assure you. So we were talking about your work with CHLP. One thing I did want to ask you before we crack into the subject matter this evening was, is your work exclusively in special civil part? Is it with landlord-tenant law, or is it people with disabilities and then other facets of the law where they're experiencing issues?
Definitely. We actually, our model is kind of a full scope legal services model. So we do a lot of housing because housing is a huge issue. So,
Hmm.
and those are usually like our highest priority cases if people are losing their housing or it's in jeopardy.
Hmm.
But we also do work in public benefit. So, we work with people who are going through Social Security terminations or applications and they need to appeal. We work with public benefits like general assistance,
Hmm.
food stamps, Medicaid, Medicare, all those things,
Hmm.
insurance issues. We also do some consumer law, so if people have debts or issues with debt. Some family law issues as well.
Sure.
But yeah, we're kind of broad brush, but we're kind of like we focus on the person and the
Yeah.
many issues that they may have because a lot of people who are facing eviction,
Mhm.
the biggest kind of eviction case that we get and that this courts get are non-payment cases. So there's always some income instability
Right.
typically with those cases. So we are able to tackle both
Yeah.
typically.
What a
So
lovely service. Thank goodness
yeah,
that that is there
I like
for.
it.
Yeah, and I was actually going to ask, like, so what brought you to this public interest type of law? Was this something that when you went to law school was something you always planned on doing? Was it an internship that
Mhm,
like sparked the passion for it? So
mhm.
how did you get involved in this?
Well, I've always been interested in public service and giving back, and so I think through college did a lot of volunteering. And actually, after college, one of my first jobs was working for a homeless service provider in New York City. I worked with seniors who were unhoused,
Hmm.
and I worked with them on their transition into housing. And I actually worked with a great attorney, Jessica Belinder. I don't know where you are, Jessica. She was an in-house attorney for this homeless. It was a drop-in center that I
Oh wow.
worked for as a case manager.
Okay.
And I saw that she was doing this direct legal services for people who were in the drop-in center that I worked at.
Sure.
I really loved it, and I really am interested in justice. But I also really like the type of legal services that I do is kind of like social work for lawyers because it's
Yeah.
really about the person. It's kind of like a crisis assistance with
Hmm.
the law.
Yeah.
So I don't know. I really like people, and I like working with people directly. So this was a really good fit for me, and I get to work with a lot of people facing a lot of different problems every day, which can
Hmm.
be, it's like really rewarding, and I really believe in it as
Yeah.
well. So that's how I got into it. It's been all along. I've been interested in it. It was either going to be a social worker, a nurse, or a lawyer. So this is sort of where I ended up.
You got two out of the three,
Yeah, yeah.
basically.
Well, I
Yeah.
wasn't technically a social worker, but a case manager. But
Yeah.
yeah, no. So this is what I've been working on. I've had it. I've done this work in different capacities over the years that I've practiced.
Yeah.
But housing has always been an issue
Yeah.
that all of
Oh
my
my
clients have
goodness,
faced
for
for
sure.
since I've been practicing. Like been practicing 15 to 20 years. So yep. So
That's incredible.
wi- wi- I'm in the right place. I truly feel.
Absolutely,
Yeah.
absolutely. Your clients are so lucky to
Mhm.
have you and have
Ditto.
your advocacy. So yeah, appreciate that. And again, thank you for your time and
Of
thank you for
course.
your patience as we
Of
work through the
course.
tech issues here. So we'll jump right into the material tonight. So again, really appreciate the time that you've devoted to us. So let's jump right in for the folks who are at home and enjoying this. Again, I do apologize if there is a lack of a video component here, but I will describe what we're looking at. Hopefully that what was meant was that there's no video of Sarah or myself in the corner, but that you can still enjoy the slides. But even if not, what we will do as a resolution to this is we will post the slides and make them available to you. And hopefully you can listen to this at another time and watch the slides simultaneously, or just have them visually available to you if you want to refer to them for your own interest. Okay. So right now, the first slide that we're pulling up is when is a rent increase illegal, right? So before we jump into, and I'll just kind of touch on these things. So as it lists here, so when a rent increase is illegal is when a landlord did not provide proper notice. The increase is what's called unconscionable, and we'll talk about what unconscionable is, or maybe what it's not. So if the increase, the outside increase limit of a rent controlled property. So basically, we'll talk about there are certain protections that are applied to rent controlled properties, and we'll talk about rent control, how it's applied in the state of New Jersey, and all of that good stuff. And then, of course, landlords using the increase to retaliate against you for using your legal rights or for reporting violations. So that is another important one. All of those things. So if they didn't provide you proper notice, if the increase is what's deemed unconscionable, and again, we'll talk about that as a definition. If the increase is outside of what is allowed by a rent-controlled property in the state of New Jersey, or what's controlled by town ordinances. And then, of course, if the increase is in retaliation for you just asserting your rights as a renter. Okay, so often people do ask, whether whether a landlord can increase your rent. Sarah, one of the first questions I thought I'd ask you as we continue our conversation, especially with the substantive information this evening, is generally, can a landlord increase your rent?
Well, yes, landlords can, with given the proper procedure, if they follow the proper procedures
Okay.
and they are increasing the rent at the appropriate amount, and that is depends on your situation how much they can increase the rent. Um, yeah, they can increase the rent as long as they're following the right procedures.
Sure.
So, if you have questions, and I'll kind of talk about this throughout, but if you have questions about a rent increase, or you're getting notice, or your landlord's telling you got to pay up, pay additional rent moving forward,
Sure.
legal services is a great place to start.
Yes.
We do look at, we look at rent increases and we talk to people about their rights. But yes, it happens, and it's a legal issue that tenants will face probably on a yearly basis in some cases. So it's really good to understand the parameters of what a landlord has to do
Excellent.
in order to raise it appropriately.
So and you talk about a process and following a procedure. So let's talk about like the timing of it. So, and that's the one thing that I see. And I come from my experience here at Family Promise of Sussex County. So, a lot of the cases that we work with, like especially in the CEDD program that I referenced earlier, that you are well aware of and partner with, we see a lot of non-payment of rent cases.
Mhm.
And I know that some of those cases pertain to not paying rent increases.
Mhm.
But before it even gets there, because I know a lot of clients come to me and they have a lot of questions in mind about whether the landlord can do that, whether they did it at the right time, and specifically regarding the timing, when can a landlord increase the rent?
Mhm. Well, it depends, but typically, there are different types of leases. There are written leases. Typically, those last for a year and then they're renewed. Some leases are month-to-month leases. For the majority of cases, you're going to see a landlord needing to give notice, or give a heads up
Hmm.
and written notice
Hmm.
of a rent increase at least a month ahead of the lease, when the lease would end.
Okay.
Sometimes leases will have a different provision, maybe a longer. Okay, well, you have to give 2 months notice for, but that's really those are the exceptions. So
Okay.
typically you're looking at a month notice at least. And
Okay.
it certainly nothing like 2 days notice. Oh, he comes around and says,
Right.
you've got to pay $100 more this month. That's not going to work.
Okay.
So you've
Okay.
got to have that time. And it's really to give the tenant an opportunity to review, to get a consultation if they can on the increase, and to figure out what they're going to do,
Sure.
you know?
Sure. Sure. And so and kind of reading some of the research that I've been looking into as well. Um, and and you may have mentioned this already, but can the landlord just, like you said, like they've got to give you notice. They can't just come around and give you 2 days to come. But what about somebody who has like a lease term that is set up? Can, even if they're given proper notice, for instance, let's say somebody has a 12-month lease
Hmm.
and they're 6 months in,
Hmm.
and the landlord sends them a note that says, "Hey, in 30 days, I'm going to increase your rent." Is that
Hmm.
something that the landlord can do?
No, they can't. They can't raise the rent within the lease term. So if you have a year lease, you're really going to be able to increase the rent right before the end of that year
Gotcha.
term,
Gotcha.
and not every 6 months, or every month. Typically, if
Okay.
you have a month-to-month lease, that can get more complicated. But again, if you have that situation, you can consult the legal services to figure out what's appropriate.
Absolutely. Okay, that's excellent. I appreciate that. So just to kind of summarize what we're going through. So for you folks listening into that, so some really important information that we were just talking about here that Sarah had clued us in on. So it sounds like even so to kind of summarize, and Sarah, let me know if you
Hmm.
agree with this summary. So
Sure.
it sounds like one, that the landlord needs to provide to the tenant written notice.
Mhm.
So that I think is one of the, and you'll see up on the slides here, folks, and hopefully again that you have a view of this. But so you need to, the notice. So whether it's month to month, whether it's an oral lease or a written lease with a term, there needs to be a written notice provided to you from the landlord. That notice needs to, if it has a term, like let's say a typical 12-month lease, that needs to come at the expiration of that lease. It can't just be in the middle of that lease. They need to give at least a month's notice, unless the lease says something else.
Mhm.
And not only that, but the written notice has to say, "Hey, the lease is ending. You got to. There's a new lease, but it's going to be at a higher rent." And I think, does that seem to summarize it? Okay.
Yeah, definitely. I think one thing, that if people are looking at your slides, and I'll just kind of volunteer this,
Mhm.
the language in a rent increase will say your lease is being terminated or
Yeah.
it's ending, and a lot of people come to me and they'll say, "Oh my gosh, what is this?" Like,
Yeah.
they want to raise the rent and they want me to leave too. It's just the language, this termination language. Like, the landlord has to put, "We're ending your lease and we're
Sure.
starting a
Sure.
new one." Doesn't mean you have to move out. It just means that the old agreement is ending and a new one is starting. But that type of language is really important, and it has to show up in the rent increase, or else it's not valid.
Oh,
So it's
wow.
one of those
Okay.
procedural things. So if there's no language saying that the lease is being terminated and the rent is being increased with a new lease,
Mhm.
then that rent increase isn't valid.
I got you.
Yeah.
So that's really, really valuable information to look out for too. So for those of you, those renters and those landlords,
Hmm.
so if you're listening to this and you're hearing this, so again, that notice needs to be given. It needs to be given, within at least a month's time. Again, unless the lease says otherwise. But for you renters, and the language will say something like, "Your lease is terminating. Your new lease you have the opportunity to sign is going to have a higher rent." And we'll talk about the reasonableness of that rent.
Hmm.
We're going to move into that subject shortly, but we just want to, again, just touch on and summarize the proper notice. So
Hmm.
that's one thing that we want to talk about, and one thing to keep your eye out for. And landlords, to practice this proper notice when giving notice of a rent increase to your tenants, and tenants make sure that you are asserting your right. Now, what would you say to somebody who, the advice to somebody who might, not receive proper notice, if it's
Hmm.
deficient in any way? but the landlord is still insisting on the rent increase, and they're threatening
Mhm.
to evict you if you don't pay it, and all this stuff. What
Mhm.
would you say is the proper course of action for somebody who's dealing with that situation?
It really depends on the person and their
Sure.
circumstances. Uh, eh, my job as a lawyer is to give people options and let them know what their rights are.
Sure.
So, and also, a lot of people are dealing with a situation where maybe they're just at the very high end of what they can afford as renters.
Mhm.
So,
That's a great
a
point.
rent increase may not be feasible for them with their income. Uh, a rent increase, they may not be able to vote with their feet and find another unit that's affordable to them because there may not be another affordable
Right.
unit.
Yeah.
So if I'm working with a client who doesn't have a lot of options and can't afford the new rent increase, then I'll talk them through what their options may be. If they don't get a proper notice, I can say, listen, if you have the right not to accept this rent
Yeah.
increase, and if you don't want to pay it because you haven't gotten proper notice, you could refuse to pay the increase,
Mhm.
continue paying your regular rent. The risk that you run is that the landlord could take you to court for not paying that rent
Sure.
increase.
Sure.
And we have, you can tell the court that it wasn't a proper rent increase. And I certainly have cases where we prevail
Mhm.
because there's no notice.
Right.
Sometimes those cases come back though. The landlord can go back and do the proper notice, and then it can result in a valid increase.
Okay.
So it really depends on the situation, and people may have some clients say, well, I have a great relationship with my landlord. I don't have like I want to make sure like this seems like like a reasonable increase, but I am a little concerned about the notice.
Mhm.
Sometimes a lawyer can help the tenant negotiate a proper rent increase so that everything is
Yeah.
laid out appropriately, and maybe we can negotiate more favorable terms. So maybe they want to go along with the increase for
Yeah.
various reasons, but we figure out a way to help them do it, help the land not really help the landlord because we're always representing the tenant, but
Sure.
we facilitate that so it's done properly.
Yeah,
Yeah.
yeah, and that their rights are observed
Hmm.
and honored, and that's really great. And one of the things that I've been communicating in this lecture series is communication.
Hmm.
I think that's really a valid, an important topic to discuss, and
Hmm.
regardless of where you're at in your landlord-tenant relationship. So, if we're talking about understanding your lease,
Hmm.
renting your new home, or if we're talking about, you might be falling behind with your rent, or
Hmm.
if you think you might have a habitability claim or something like that.
Hmm.
I've always been talking about communicating with your landlord
Yeah,
to make sure that you can express, and again, knowing this information is really helpful in that communication as well. So I think that's a really
definitely.
good point.
Yeah, communication is really important, and also I think I'm a tenants attorney, but I have worked with a lot of mom and pop landlords
Hmm.
who don't understand some fairly complicated procedures for raising rent,
Sure.
or increasing rent. So it is important for landlords to also educate themselves or
Yeah,
find an attorney to help them through that process because I think that's it's really important to be educated about it
absolutely.
as a landlord, especially the smaller ones that are just kind of they're renting and a few apartments here and there.
Right, right.
So, but yeah, communication is key. And that's why there are notice requirements for
Right,
rent increase. This
right,
is
right.
about letting people know what's coming and
Yeah.
giving them a chance to figure out what to do.
Yeah,
So,
because it really is, and I agree. It's so complex, and
mhm,
I mean, we're kind of touching on, we're painting with broad strokes
yep,
for the purposes of this class,
mhm,
but there's a lot of nuances and there's a lot
mhm,
of procedure
yep,
that an expert like yourself is crucial. It's
mhm,
imperative to have. So I'm glad that we can kind of touch on some of the broader points
mhm,
about
of
that. But if I may
course.
back you up real quick with regard to, you had mentioned the notice itself
Mhm,
with the language saying that your lease is terminated, but you don't have to leave.
mhm,
So, are you saying that? Because that's one of the things that I often see too, and I find myself kind of like, well, I don't know. One, I don't want to give legal advice, but secondly, I don't know the answer. Like, so when someone comes to me and they say, hey, my landlord doesn't want to renew my lease,
Mhm.
and I know that's a whole different thing as opposed to rent increases, but just with the general topic of, your lease is ending,
Mhm.
that you're saying is not grounds for eviction. Like, you don't have to leave just because your lease is ending.
Mhm.
What does that typically look like? Like, let's say the lease term ends, the landlord, like what's not necessarily what are grounds for eviction, but like I guess what I'm asking is, like, when the lease term does come to an end and it's not grounds for eviction, like, is there any instances where the tenant should be worried, like, when the lease term comes to an end, or in New Jersey are they completely protected?
Well, so we have a really great law called the Anti-Eviction Act, and New
Okay.
Jersey is like one of the best states to be a tenant because there are a lot of strong protections to keep people in their rental units. And the Act covers most rental units, I would say. There's some that aren't covered because there's some exceptions for small buildings where there's an owner living in the unit.
Hmm.
But those are exceptions to the rule.
Hmm.
The rule is that a landlord has to have a good reason under the law to evict their tenant, and it's not just the lease ending. In
Right.
fact, if a person's lease, say you live in an apartment building and your lease is coming up at the end of June, and the landlord doesn't present you with a new lease, well, just because he doesn't present you with a new lease doesn't mean that you no longer have a lease. You then have a month to month lease with that landlord at the same terms. So even if you don't have a written lease, you can still have a lease
Right.
and still a right to be in your unit.
Okay.
And really, the only way you can be removed against your will is if there is a court process and the court decides whether there's a good reason to have you leave.
Right.
So the biggest reason for eviction, one of the biggest grounds for eviction that's asserted in kind of the majority of cases throughout New Jersey, I think, is non-payment of rent.
Sure.
So if
Yeah.
you don't pay your rent, if you're even short a little bit, and you go before a judge and the judge sees that you owe rent, you can be evicted for that. And of course, we try to forestall that, and I'll
Hmm.
figure out how to work that out. Other grounds are if you're being a disorderly tenant, if you're creating, kind of disturbing the peace
Hmm.
in maybe a larger building,
Hmm.
or creating a disturbance to your neighbors, destruction of property, intentional
Sure.
or
Yeah.
willfully. Those are like the big ones that we see.
Yeah.
And sometimes a landlord can cite as a ground for eviction if they intend to move into the unit themselves.
Oh,
So
wow.
that's
Okay.
another
I
one
got
that
you.
we see a fair bit of as well. So, but yeah, there has to be a good reason. It's just not when the lease is over.
Right.
And
Okay.
and and people don't know that. They're like, "Oh
No.
gosh, the lease is
No.
up. I gotta go because the
Yeah.
landlord hasn't given me a new lease." Well, that's not typically the case. I mean, there are some exceptions, like I said. Another reason to talk to your local legal services provider, but because it is there can be these
Sure.
situations where you're not covered.
Yeah.
But yeah, no, it's anti-eviction act. I love it.
Yeah.
It's a great tenant protection in the state of New
And that's
Jersey.
what I've heard about New Jersey, is that it is a very tenant friendly state,
Hmm.
and that there's a lot of protections there. So that's
Yeah.
really good to know. And so I hope you listeners are hearing that as well.
Hmm.
And it's very important to know that just because it's ending, and again, with a few
Hmm.
exceptions, but generally speaking, that just because your lease is coming to an end, and just because, as it relates to this subject matter, you receive notice that says your
Hmm.
lease is coming to an end, doesn't mean that you are being evicted or that you have to leave. But we are talking about rent increases. So let's go back
Hmm.
to proper notice. But I want to thank you for
Sure.
indulging me on that. And
Of
again, I
course.
always think it's important, especially because one of the things that we see most commonly here in Family Promise of Sussex County is, like you said, non-payment of rent cases.
Hmm.
But we get a whole array of questions, and of course, we
Hmm.
always send them over to legal services. But I'm curious myself because I don't know. I'm not expert in this like you are. So it's really interesting to know the law that's out there, the rights that they can assert at that
Hmm.
time. So that's really powerful, important information to know. So thank you for sharing that, Sarah.
Of course.
As we move forward, so proper notice. We talked about what proper notice looks like, and we can go ahead and move forward. So let's go on to the next. So unconscionability is going to be the next terms that we talk about. So what I guess we're talking about then is, first when you mentioned earlier when you talked about how a landlord has to, in order to successfully assert or to have successful grounds for a rent increase, like it has to be done at the right time. There has to be proper notice given. It has to be written. It has to explain specific language and XYZ. But there's also an amount, right? We also have to consider the amount as
Mhm.
well. So it's kind of a bifurcated or a twofold kind of consideration. It's not just
Mhm.
the notice, right? Because you can argue that in court and say,
Mhm.
hey, I didn't get my proper notice,
Mhm.
but the case does have the chance of coming back if they do then give you proper notice and if you come
Exactly.
back your way.
Mhm.
So then the next thing is, well, is the rent increase itself reasonable, or is it what's called unconscionable? Before we get there, what are some of the things that, like, so just real quick before we get into unconscionability and the reasonableness of a rent increase, um, what happens, if we could talk about it just briefly, like what happens if, and I know it's gonna come down to it depends, right?
Yes.
But like
Definitely.
generally speaking, like if somebody doesn't pay the rent increase, like let's say they go to court
Mhm.
and like, is the unwillingness to pay the rent increase itself like grounds for eviction?
No, not at all. The way that a landlord would go to court if you didn't pay the rent increase is they would say you're not paying. You haven't paid the rent that is owed. So it would be a non-payment case. That's how it would go into court.
Okay.
And then when you will go into court with hopefully your lawyer, maybe hopefully that's the case. And you'd argue, like, listen, we have been paying the rent, but the landlord raised the rent and it wasn't done properly,
Mhm.
or it's an unconscionable amount. Like the landlord raised it 100%. 100% is like a pretty clear unconscionable. Like
Right.
that's a pretty big
Right.
percentage.
Yeah. Yeah.
That's a pretty like that exaggerated. It probably has
No, but
happened,
I
but
mean, yeah, it
it
helps
happens.
explain what that is. Yeah.
Yeah, so like they raised it too much. It's like too much of a rent increase. So yeah, you don't get in trouble. I mean, the thing that I always like to talk to people about risks when they take a particular action. Like a tenant that chooses not to pay their rent increase does face potentially getting taken into court. And some people don't mind that. Some people really, would prefer to stay away from court at all costs. So yeah, you're not really in trouble, but there could be litigation, as they say. You could end up with a
Right. Right.
complaint in eviction court, which is not what everyone wants to do all the time.
Of course. Of course.
But you can assert your rights that way. That's
Sure.
exactly how you do it. It's similar to other types of. You're going to talk about habitability next week. One of your rights is to not, to withhold rent. So, but you end
Right.
up in
Yeah.
court. There's a consequence. So
Right.
you're
So
not in trouble, but there is a consequence of having a filing against you.
gotcha.
So,
So it's like you can not pay you could not pay the rent increase,
hmm
but be prepared that your
yeah,
landlord also has then the right to sue you for the non-payment of that rent increase,
exactly.
and you're going to go to court,
hmm
and you're going to have to. There's going to be a whole procedure there that we'll touch base on.
Yep.
We'll get into that, but
Sure.
let's circle back to unconscionability. So,
Yep.
folks, the next slide that we can see, and hope we can make available to you, is unconscionability. So we're going to talk about what unconscionability in rent increases is. So, Sarah, is there a definition? Because I don't know if you folks can see it, but the picture that Don has put in the slide for unconscionability is really great because he's like, I don't know, he's got his hands up. So it's really great, and I think this is a great segue into that question. Like,
Mhm.
is there a definition as to what an unconscionable rent increase is?
No, there's not. But there's some factors that courts look at. And just to kind of back up, like a little bit, and just to frame this out, like in New Jersey, there's not like a percentage increase statewide where the state says, okay, landlords can raise the rent no more than 5% a year. That's not a state law. So there's not a state law saying there's a limit to how much you can increase the rent. Some cities and municipalities and townships do have those types of limits. They say
Mhm.
you can only raise it 5%, 4% a year. And there's some requirements, but that's township, municipality, or city by city. So some people may be covered by that. Not as much here in Sussex County as I was telling you before,
Right, right.
but it's something to look at. So there's not like a magic number unless you have rent control. That's what's called rent control.
Mhm.
There's no magic number, no magic percentage that's unconscionable or unacceptable to the courts in the state of New Jersey.
Okay.
Instead, the court, if you say, hey, listen, my rent is unconscionable, it's too high,
Mhm.
the court's going to look at a variety of factors.
Okay.
And every court's different in how they look at the factors, too. But some of the common ones are the percentage of the increase, for example, 5%, 20%, 100%, that's
Right, right,
less
right.
likely,
Right, right,
but
right.
they'll look at the percentage.
I'm sure it happens. It's got to, you know?
There's, yeah, like you see some strange things when
Yeah.
you practice long enough. But
Yeah.
so there's that. There's also, they look at, the history of rent increases in the unit. Like, has there been a rent increase recently? Have they not increased it for 10 years? They may look at this is a tough one for us. Some judges look more at this factor than others. They may look at what other market rents are in the neighborhood. So
Mhm.
I work in Elizabeth, and we also work in Jersey City. Jersey City is like, the rents they are going up.
I
They
bet.
continue to go up. And if you're a tenant who's been in a unit for a while at a certain rent, all the other units have been going up and up and up,
Yeah, yeah, yeah.
then it's not great if the court's looking at what the market rents are. So
So
that can be an issue. And also, like, the court may look at what the landlord's costs are in maintaining the unit as a rental unit. And there are different like ways that the court will look at that, but there are a variety of factors, and the court is going to look at whether the rent increase shocks the conscience, and not simply whether it's unfair.
Yeah.
The rent increase may be unaffordable to a tenant, but it may not be unconscionable.
Sure,
So
sure.
something that we like to talk to people about before they get to court is, is this affordable to you? Like, are you going to be able to pay this rent increase if the court approves it? We have to
Right.
do a little planning around that, because you may fight it, but the court may ultimately say it's not affordable to you, but it's still fair.
Right.
It's still not unconscionable. So
Right.
every case is different. A case decided in Union County with a particular judge may be decided by a judge in Sussex County with a different judge in an entirely different way.
That's so interesting
Yeah.
that there's no like controlling authority as to like what they can like what
Yeah.
but it makes sense when you think
Mhm.
about it, because like the way that the housing market
Mhm.
is that you really couldn't have a uniform. I mean,
Mhm.
geographically there's such a difference between what the rent would be in
Mhm.
somewhere like rural Sussex County
Mhm.
as opposed to somewhere closer in
Mhm.
Jersey City.
Yeah.
um, so that's really incredible, and that I love that phraseology. Shocks the conscience. That
Mhm.
now, if you could, so that's not your term.
Yeah, that's
Shocks the
like a
conscience.
common legal term. It's when we have it lost. We hear it all the time in law school.
Shocks the conscience. I
Yeah.
love that. I love that. That's great. So
But
I'm gonna.
but what shocks the conscience for some people, like
So
if
dramatic.
well, it's different. Like if you're somebody, maybe a judge had like, everyone can look at a case differently. Maybe you're somebody who has been a landlord before,
Mhm.
and you understand what it takes to rent a unit, what the costs are to maintain a rental unit, or and then maybe a rent increase doesn't shock your conscience. That may shock
Sure.
the conscience of somebody who doesn't have that experience. So
Right.
it's kind of it's a bit it's supposed to be objective, but it's not really.
Right.
It can be very subjective
Is it
depending
like
on the
this
judge.
reasonable person standard?
Yeah, it's supposed to be a
Yeah.
reasonable person, but there are a lot of reasonable people out there. So
Getting
so
shocked.
anyway, but it is like, we when we look at cases, we do, like I said, we have to an unconscionability argument. You have to really prepare a tenant to to say, listen, this could go either way. Some
Yeah.
things are clear, like 100% increase.
Yeah.
Oh
Like you were
yeah,
saying.
definitely. But like a 7%
Hmm.
increase
Hmm.
that it goes beyond what a person can pay. That's a harder thing to argue for sure.
Yeah.
So they're not always slam dunk cases.
Right.
That's like what I like to say, but you can talk about what your options are with an attorney, or with an attorney. Because we're
Right.
always
Right.
like, go to an attorney, but
Right.
and figure out like, again, you have to figure out, like, if you lose the case, kind of
Right.
what it's looking like.
Right.
But one thing, we had a recent unconscionability case that we worked out of our office. There were some bad factors. There was some retaliation going on, we thought, too, with
Oh, wow.
related to the rent increase, which can happen.
Yeah.
But the we had to prepare our client by saying, listen, you may need to pay this rent increase if the court doesn't go your way. And we really had to say, listen, you have to save some money up just in case you're going to be
Mm.
held to pay that extra increase at the close of the case.
Wow.
So that's something to consider too.
Yeah.
It's a kind of
'Cause you could
financial
lose.
planning thing.
Yeah,
You could lose.
exactly.
So I don't like to discourage people, but we have to, if you're in court, there are these some realities
That
you
is
have
so
to prepare
huge.
for.
No, and that's so huge. And I'm glad for our listeners, as well, that if you're hearing that, it's so important here because you are getting some really exceptional advice. Saying that in the event that you need to be prepared, and it depends. And
Mhm.
there's a lot of these what are supposed to be objective, but
Mhm.
that's kind of unclear too. And
Mhm.
and what could be unconscionable to one court might not be unconscionable or deemed unreasonable to another
Mhm.
court making that determination.
Yep.
But um, you know, so it's important to prepare, and it's
Mhm.
important to make sure that you have your ducks in a row. Not only, hopefully your legal counsel will be
Mhm.
able to make those arguments and have the evidence to prove that it's either unreasonable. First,
Mhm.
obviously, they would start to say with the improper notice.
Yep.
If that fails, then they got to go with the reasonableness of the rent
Mhm.
increase itself.
Yep.
But if that fails as well, then you got to make sure that your fiduciary or
Mhm.
your legal representative is saying, hey, make sure that you've stowed away some money because you're going
Mhm.
to be expected to pay this in the event that
Mhm.
the court rules against you.
Exactly.
Okay,
Yep.
very good. All right, so now in the event that, actually, let's pause for a quick second because I did get a text message and I think it's actually good. Um,
Okay.
I think it's saying that we can be seen now. Let me just verify that. Unless it says I can't see you. Let's see. There's no video. Video is on. No PowerPoint showing. Sound is great. Can see you now as well. Excellent.
Oh, great.
So
Okay.
it's like you're great. You stink. You're great. You stink. No. Great. I'm glad. And thank you so much for letting us know that. So it looks like we've got video, we've got sound, we've got the kinks worked out, and I feel a little bit better about myself as a
Don't
human being.
let technology dictate how you feel
Oh
about
yeah,
yourself.
it's getting way too easy to apply that as a standard going forward. All right, so looking at the slide, so unconscionability, if we're looking at that, must not be extremely harsh, or so in terms of not being unconscionable. So the rent itself must not be extremely harsh or so unreasonable as to be, like we said, shocking the conscience of
Mhm.
of a reasonable person.
Mhm.
It's determined by the facts of each individual case.
Yep.
And now we're moving into the burden of proof is on the landlord. Before we touch on that, I'm just going to stop my screen for a moment um, to see if we can. Let's bring up. I don't believe there's. I just wanted to double check to see if there were any chats, anything going on there. If we had any questions coming from the group. Sometimes they do come at the end, but it doesn't look like we have anything at this time. So, but I've asked you a lot of questions anyway
Well,
that
we're
I
just
think are really
answering
good.
all the questions.
Exactly. So there's nobody that wants to know any additional information. But if you do, please do ask in the chat. And maybe people have been discouraged. So I do have to
Don't
say
be shy.
I'm particularly long-winded. Some of the seminars I've done on my own, and we'll get to the end, and I'll be like, oh, we don't have time. And there have been a couple questions. So please, I'm taking breaks now. Sarah's here and myself as well to answer any questions that you may have. So please feel free to go ahead and write any comments or questions that you have in the chat, and we'll check them out and we'll try to reserve some time here at the end as we proceed. But I'll go ahead and continue sharing my screen. We'll bounce back to the PowerPoint presentation. We'll keep rolling through here. Let's go ahead and pull the slideshow back up from current slide.
Oh, there you go. That's a great slide.
So yeah, so like we said, burden of proof is on the landlord. So just as a quick point, what I was seeing, if someone finds themselves in court, and they say, "Hey, I'm not paying this rent increase," and the landlord ends up taking them to court to pay the rent increase, because that's the consequence that you have to potentially deal with if you don't pay the rent increase.
Mhm.
Who's that? So in the slide, it says burden of proof is on the landlord. What is it exactly does that mean?
Well, the landlord has to prove they're the ones that have to show the reasonableness of the rent increase, that it's not unconscionable. I mean, in practice, though, even though it's on the burden is on the landlord, they have to show all the evidence to show that it's not unconscionable. It's still helpful for the tenant to go to court to bring to court any evidence they have about why it's unconscionable.
Sure,
You know,
sure.
so if you have evidence that they're saying, oh, they've had to make all these upgrades,
Hmm,
uh
that's good. Yeah.
and they're supposed to show evidence of the upgrades.
Right.
That's their burden. They have to present the proof. But it's also good for a tenant to come in and have pictures of the toilet that doesn't work, and to show that there are no upgrades
Such
here.
a great point.
So yeah, technically the burden is on the landlord to make that showing of why, this 20% increase is valid.
Mhm.
For example, they have to bring the paperwork and show the history of what they've done in the unit, what maybe the market rents are around
Mhm.
the area, etc. But again, look, the landlord or the tenant, if they have some evidence that it's really not the case, but the landlord is saying, then they should
Right.
bring that evidence in too.
Okay.
Yep.
Excellent. That's good to know. And what do you see like so? And I know you've been to court in this capacity, and you've worked with litigants, and you as you represent tenants, who are dealing with rent increases. And what's kind of like the general like experience that you have in this realm? Meaning, like, what how does it usually run, like, and what I mean is, for people who
Hmm.
are represented versus those who
Hmm.
aren't represented, what does it kind of look like? What, in your experience, like, what do you generally see, like, in the courtroom, for someone who's trying their best, with the information that they have, to represent themselves, what is called
Per
pro
se.
se, right? So they're representing themselves, and they try to go through the complicated procedure, and what are the common missteps that you see when someone is trying to raise a defense, if their landlord is saying that they haven't paid a rent increase?
Well, I'm trying to, in general, I haven't seen a lot of pro se tenants litigate these cases, and mostly because I am not always in court when it happens. But I would say, you know, some tenants will just rely on the fact that it isn't fair.
Right.
Like, what? It isn't
Yeah.
fair.
Yeah.
You've got to show, you got to talk about percentages. You've got to talk about the condition of the apartment and that
Hmm.
sort of thing. So when you're talking about unconscionability, the other thing that the like when I go in as an attorney and on these cases, it's usually a non-payment case. So
Hmm.
it looks like the tenant's not paying rent. Well, you got to I go in and I say, listen, judge, there's the landlord says there's non-payment here, but this is actually a case involving a rent increase that wasn't appropriate.
Hmm.
So
Hmm.
if you can kind of get that out in front of the judge really quickly on,
Hmm.
then the judge, as they should with a pro se or self-represented tenant, they're supposed to kind of walk them through, what
Fair
are the
enough.
facts.
Yeah.
They'll
Fair
walk them through
enough.
the factors and
Yeah.
ask them to provide proofs of these things, and ask the landlord,
Right.
obviously, because they have the burden of proof. So you really, like, if you have an idea that this is a case involving an illegal rent increase, then you need to flag that for the judge right
Gotcha.
away,
Okay.
and go in with your paperwork. Some people don't have their paperwork printed out. They maybe have something on a phone, or they have, maybe they have a friend who can talk about it, but the friend's not there with them,
Right.
like a
Right.
witness
Right.
who's not there.
Right. Right.
So it's really about preparedness too.
Okay.
So making sure you have all the paperwork that you think helps you,
Sure.
print it out the day of court. um, so that's generally what I would say. But you got to know, to the judge, you can't just say it's not fair.
Right.
You got to be able to provide a little bit
Right.
more detail,
Right. Right.
right? Because landlord tenant court is not fair.
Right.
sometimes.
Yeah.
Like
Yeah, I've seen it myself,
what is
for
required
sure.
under the law is not always what seems fair to us, or to
Right.
tenants who
Right.
often are going through like, maybe they'll go in and say like, I am going through health problems, or my mother died and I can't pay this increase, so it's unconscionable. Well, no, it's not. People go through really bad circumstances, but
Yeah.
that's not always going to be what the judge is going to be hearing
Right.
or able to consider in making their
Right.
decision. So that's that's what I would say in general.
Great
But
point.
but judges, when you pro se, they are required to kind of help you through things.
That's good to know. That is good to
You
know.
need to be prepared, but they are there to help make sure that they're getting the testimony and evidence they need to make their decision from
Very
you.
good.
Yeah.
Okay. And I think that also goes with the through line that I've been trying to communicate through this series is that early intervention is appropriate, not only with the communication to your landlord, but I
Hmm.
would say if you need a lawyer, if you need one that is more on the affordable side, so like if
Hmm.
it's free representation or low cost legal
Hmm.
representation, whether it be through community health law project or from legal services of
Hmm.
Northwest Jersey, would you say that the earlier that
Oh
someone
yeah.
gets involved, the better?
Yeah. We
Because
don't want you to have a court date.
right,
Like the best time to come is when you get that rent increase,
okay,
or when the landlord's coming knocking and saying, "Listen, it's time to pay this increase. I expect $50 more
right,
next month."
right.
So I think some people feel very sheepish coming to legal services. Many people have not worked with an attorney before. And so it feels very, really worrisome to them.
Sure.
But it's, for if you have free legal services available to you, like utilize them, and always check in, and we may be able to refer you if you're not eligible, due to your income. We can refer you someplace else potentially.
Excellent.
Yeah.
Excellent.
So
That's
yeah,
good.
earlier the better.
Earlier the better. That is great. So, very good. So, and then just to kind of summarize, the considerations of the court, with regard to unconscionability, and we'll move on. The amount of the proposed rent increase, what similar rents are being charged in the same geographical area. Excuse
Hmm.
me. The manual that I'm reading from the
Hmm.
LSNJ landlord tenant manual also mentions the relative bargaining positions of the parties as well.
Hmm.
Then, of course, that shock the conscience of a reasonable person, which I think is,
Yeah.
again, I just love it's so extreme,
Well,
that
yeah.
it seems like, it really does. It seems extreme, like the shock the conscience
Yeah,
of,
it does. I mean, that's kind of the way that there's no statute about this, but it's
right,
it's in the case law. It's interesting to talk about the relative bargaining power of the parties, and you know, it's interesting because I deal mostly with people with fixed or limited incomes, and there is going to be a bargaining. There's just going to be an inherent difference between the bargaining power. Like,
sure, sure,
a tenant can't just simply go and find another place to live that easily. But yeah, there are maybe situations where people are more equal in their situation. Like you have, somebody with a higher income
hmm
who has more options out there.
hmm
That's going to be a different factor. Like if you have a higher income client with a landlord, and they can, So I just wanted to point that out. But most of
yeah,
the time,
yeah,
we're dealing with people who have absolutely no bargaining power as
yeah,
opposed to their
yeah.
landlords.
Same here. Yeah.
So yeah.
Yeah, like when we're there in CEDD court, and it's eviction,
Mhm.
based, that's usually where they're at. Is they're being evicted, and largely the cases we see are non-payment of rent. We often see that the people who often have the money for a private attorney
Mhm.
are the landlords
Oh,
versus,
yeah.
the tenants who,
Oh,
if
yeah.
they can't pay their rent, how are they going to afford a private
Oh,
attorney?
yeah.
You know what I mean? So
Yeah.
again, getting involved with these, because my understanding is that your right to legal counsel, it doesn't attach in a civil trial as it
No,
does in a criminal trial.
there is no right
So
to counsel in
right,
eviction cases, although people do believe, in some jurisdictions,
yeah.
including New York City, they've talked about a right to counsel where you do have more of a right to have somebody there
Oh
with
wow.
you. Yeah, and actually, there's talk of that in the state of New Jersey as well.
Oh, that's
So,
great. That's
so
great.
yeah, and
Great to
when you
know.
think about it, the loss of housing is the loss of a basic need,
Sure.
and
Yeah.
so if you think about it that way, it really does make sense for people to have access to
Absolutely.
counsel.
That's great.
So
I didn't know that. That's an excellent
yeah,
bit of information. I love that.
yeah.
Okay. Well,
It's a thing.
great, state of New Jersey. I love that. That's wonderful.
We liked it where there
Good,
people are talking about it.
good stuff.
So
Good
hopefully
stuff.
it comes to
Hopefully, yeah.
pass.
Again, we're moving forward. I love that
Hmm.
conversation. Okay. Well, let's go ahead and move forward then. So we all. So I think we
Hmm.
kind of touched on this already. For those of you who are, and it sounds like you're able to see our slides at this point, but we kind of talked about the considerations as it pertains to rent increases.
Hmm.
So we're going to go ahead and move on because I think we talked about that
Yeah,
ad nauseum.
sure.
Well, not ad nauseum, like really
No, it was great.
informative, wonderful conversation. It's really just great, such helpful information, and our audience absolutely appreciates it. So thank you, Sarah,
No
for that.
problem.
As we move forward, as we close out this presentation, let's just round it out because you had mentioned that this unconscionability aspect of a judge making a consideration, the two-pronged kind of, the note. You got the notice, you get the proper notice of the rent increase from the landlord, and then you've got the actual reasonableness of the rent increase itself. But my understanding is that that's not necessarily an applicable standard to all cases, and
Hmm.
especially when it comes to rent control
Hmm.
and people who receive subsidies. So my understanding, Section 8 recipients and other subsidy or voucher recipients, there are special federal laws that dictate how their rent can be increased based on their income.
Hmm.
But if you could kind of talk about just rent control, because you had
Yeah,
mentioned that and again, referring to this wonderful legal services of New Jersey manual that I base much of my research on, is really great summary of the law. Um, that says that there's more than 100 cities and townships in New Jersey that have passed rent control ordinances. So my understanding is that it's not at the state level.
hmm,
There's no codified statute, that controls rent increases at the state
hmm,
level, but it's really up to the towns in the state of New Jersey to kind of as to how like rent increases
hmm.
happen. So in those towns, for those of you who are listening, if you live in one of those towns, and if you're not sure, I assume you can reach out to like your city or town hall,
That's
maybe
correct.
like the
Yes.
clerk's office or
Hmm.
something like that, and try to see if you are in one of those townships where you have a local ordinance. And an ordinance is, I think, is just a fancy word for like a town law,
Yep.
right? It's
Exactly.
a law. It's a law at the town level that will control. So whether your town controls whether there's a rent increase cap, or the town will kind of oversees or controls how that rent that increase is implemented. But can you kind of tell us like how, like walk us through, and it does outline that in the slides
Sure.
here. We have the two different types of increases. So when there are rent controlled units, so when we refer to units that are the town decides that how your rent can be increased. Can you talk about the two types of increases and kind of how that
Hmm.
process works?
Yeah, so rent control or rent stabilization, the state does allow all of its municipalities to decide whether they want to do a rent, whether they want to enact a rent control or rent stabilization ordinance or law. And I wish there were more of more of them myself,
Yeah,
because
yeah, for
not, I
sure.
mean, it's obviously tenant friendly because it does put a cap on increases, but it also just makes sure that the parties know what to expect. The landlords know what is a reasonable increase. There is a process for doing that that's even more structured than what we've already talked about with the notices. So there's a nice, the expectations are set by all parties, which I think can be a really good thing.
Yeah,
So,
for sure.
but every rent control statute or ordinance is different. Like when I hear about a rent control issue, I'm always looking. East Orange is different than Newark, is different than Bloomfield, and those are the places where I work a lot,
Yeah.
or have.
Hmm.
Elizabeth is different, so I have to look. But typically, the rent stabilization ordinance is going to have like a cap on a percentage cap on the annual increase, 5%, sometimes 4%. We see for people, they may do a lower percentage for people with disabilities or elderly people.
Okay.
Um,
Is that because they have a fixed income?
yeah,
Okay.
yeah, it's sort of assuming people have a fixed income
Okay.
or a lower income, um, depending on the situation. So that's not always the case, but there's an annual cap, and there's also usually another type of increase that they can seek called the hardship increase, where they can seek an exceptional rent increase above that 5% or whatever that annual increase
Okay.
percentage is set at. If they have certain hardship circumstances where, for example, like they may have extraordinary repairs that they or upgrades that they need to make that require them to be able to increase. But they usually have to show that to the rent, what we call the rent control board or the rent stabilization board. There's usually a body of people in the city government who make sure that everyone's following the law, and they will hear.
I really like that.
Yeah, it's really
I like
cool.
that. Yeah.
Yeah. So, like I said, they're all different. All these different laws have different provisions. A lot of them, though, if you're governed by a rent increase and you get a rent increase notice from your landlord that looks fishy or above 5%, for example, above that threshold, you can go down to the rent stabilization boards, usually in your city hall, and you can say, "Hey, I'm looking at this. It seems like it's not quite right." You can file a complaint with the rent stabilization board and then seek their guidance on whether it's a proper increase.
So it's kind of a different process. So it's not necessarily. Could it ever eventually go to the courts?
Sure thing, it could. Yeah, it certainly could. And it may go to court because people don't know that there's rent stabilization. Like may not know they can go to their city government. So then it becomes an issue where there's a non-payment case. So and the courts have to hear information about the rent stabilization.
Gotcha.
Yeah, or the rent control. So yeah, it's great. I mean, it's the gold standard. Really, we really, if the rent control case comes in, we're like, yes, because it's like, okay, 5%. We know what the maximum rent increase is here.
It's so
we don't have to think, oh, what's unconscionable here. It's more of a certainty.
That's why it's so good, because it truly is an objective standard. That's great.
Yeah.
Very good. Okay, so just to kind of, again, folks, for you guys listening in. Just want to kind of summarize the great information that Sarah, once again has provided to us. So it sounds like they're, bifurcating it into two different types. So for those of you who, if you find out that you happen to be in a rent-controlled area, your local city or town government has a rent control board that you can go to in the event that you feel that your rent increase is above what the standard is set forth by that local entity. And you've got your annual increases, which seem to be based on kind of like an automatic certain percentage each year. And then there's the hardship increase, which might go above that annual amount, but it sounds like the landlord needs to prove why they need to go. Because are there situations where the landlord justifies that they can go above that hardship amount?
I'm assuming so. I don't typically see those types. Those aren't as common.
Okay.
I don't see those as much, but yeah, I'm sure there can be situations where they can seek that and obtain it through the city government. So, and there are also different provisions too. Like landlords may be required to every year file their increases, or they may just be spot checked by the local government. So it's kind of, there are all sorts of different ways that the city governments review the annual increases to make sure that they're appropriate. So,
okay,
yeah.
Excellent. But but tenants can be part of that process, right? They can attend these hearings, they can go to meetings and things like that.
Yeah, I think it depends, like how the rent control board or the committee reviews these things. I think it may differ, but yes, there's certainly it is typically, based on my experience, yes, the rent control boards are looking for tenants to bring issues to their attention, and they have a process by which they look at those issues. And also, a lot of rent stabilization and rent control ordinances also contain other provisions for penalties to landlords. For example, if they're not providing appropriate heat, or so there are other cool provisions in different cities' laws. So it's definitely worth it. If you have a rent control ordinance in your municipality, you should go and check it out. And a lot of the rent control people are really helpful.
That's wonderful.
And like to provide the information.
That's great. Yeah. That's great. That's really good to know. So please, for you listeners out there, please, if you're not sure, look into it. And again, you can go to your local town government, your town hall,
Mhm.
and see if you do live in a community where there is rent control. And if that is the case, then your rent increases are capped to a certain amount. Of course, like we said,
Mhm.
your landlord can, with a hardship increase, show that there's a need for increasing beyond that preset amount.
Mhm.
But it sounds like they can be part of that process and be part of those
Mhm.
hearings
Yeah.
and all that good stuff. So thank you for summarizing that for us. And I believe so. We do have challenging a hardship increase. So
Mhm.
and through the some of the research that was done here, there are steps that, so if you receive notice, so I believe that per the LSNJ manual, that there are public hearings when a landlord, I guess, is attempting to
Mhm.
institute a
Mhm.
hardship increase. And the slide mentions that if you do receive notice, which I
Mhm.
suppose you're supposed to receive,
Yes.
that your landlord is applying for a hardship increase, that there are several steps you can take. And we have that notated here on the slide, that you should immediately contact your rent control board and ask them for a copy of the ordinance, a copy of the landlord's application for a hardship increase, and information on when the hearing on the hardship increase will be
Mhm.
held by the rent control board.
Mhm.
So that's some useful information for you as well. So just want to let you know. So there are those types of rent
Mhm.
increases. Find out if you are in a rent controlled township. If there are those ordinances that
Mhm.
control the amount of rent that your landlord can increase the rent. And if they go above it, you should be part of that hearing process. You should receive notice of that. And if you do, please make sure that you get a copy of the ordinance, a copy of the landlord's application, information on when the hearing is being held. You want to use the information to convince. The board that the landlord is not suffering a hardship under the terms of the ordinance. The request should never include costs to convert the building into a co-op or condo, and you may want to consult the lawyer. That always sounds like
Yes.
very sound advice. That is probably
I'm just trying
one
to
of the
keep
most.
myself in business here.
That's probably the most important, that one of the most important little bits there. That is that rounds that
Mhm.
aspect of it out. One of the final slides that we have with regard to that. One of the things that I did, so illegal rents under rent control is probably one of the last things that I just wanted to touch on, because we did talk about being part of that process if there is a hearing, and you can examine the hardship application. You can provide evidence as to why your landlord is not actually indeed suffering a hardship. And I think you mentioned too that you can point to evidence of like habitability issues and
Mhm.
things like that.
Yeah.
Like look, like there's things that haven't been done at this property, like
Mhm.
so.
Yep.
And it sounds like these boards too can also make a decision that even if they might go above what the annual increase is, I don't think that necessarily means that the landlord gets what they want in
No,
every
they
instance
can. They
either.
might be. They might mediate that amount they're seeking to something that
Gotcha.
makes sense to them.
Okay.
It depends on, like I said, every ordinance is different. Every city is going to handle it different. Every township's going to handle it differently. But yes, yes,
Okay.
definitely.
Excellent. So one thing that we didn't have on the slides that I just wanted to read through from the LSNJ landlord tenant manual that I thought was really interesting, that I thought
Hmm.
the audience listening could find helpful. And if you think this is accurate, let me know.
Definitely.
So glad to have you here. Contact your regional legal services program, a private attorney, or your local tenants organization for help. You can also get, so it says you can also get your overpayment back. So I guess if it's found that your rent, the illegal rent under rent control, that you can get your overpayment back by taking it out of future rent payments, is something that's possible. It says courts have also ruled that landlords who charge rents that are illegal under a local rent controlled ordinance have violated the NJ consumer fraud law, which means that they can be sued for 3 times the amount
Oof.
of the illegal increase and must pay the tenant's attorney's fees as well.
Yeah, there are
So,
all sorts of cool wrinkles.
so
And I will say, I think that every rent control ordinance is different in terms of what they require in terms of paying that rent. You may be
Sure,
required to pay the increase for a while until
sure,
there's a determination
sure.
about whether it's valid or not.
Excellent.
So consult your local rent control ordinance. I also was reading. I think there are also some specific rent control ordinances that are specific to mobile home.
Oh, okay.
So I'm not familiar. We don't practice as much in that area in my neck of the woods because we don't have mobile home communities.
Sure.
But definitely worth a look if people have those circumstances. So there's some
Excellent.
protections there for folks.
Great.
Yeah,
Thank you, Sarah.
no problem.
So, and then finally, the last thing that yes, and I believe this is the last slide that we have is
Yeah.
retaliation.
Uh
So,
huh.
the law does not allow your landlord to increase your rent in order to get even with you because you are using your legal rights as a tenant, or because you have reported housing and health code violations
Mm-hmm.
to official inspectors, or because you belong to a tenants organization.
Mm-hmm.
So, simply asserting your rights is not a reason for someone to increase your
Mm-hmm.
rent. So as we, we cap off this session,
Mm-hmm.
this module, for anybody, and your last piece of advice here as we close out, for anybody who feels that they either have been retaliated against, like let's say if they just feel that they are wrongfully being presented an illegal rent increase or a wrongful rent increase, what's the best thing they need to do or start to do before anything? What's the most important, bit of information you can instill upon them? Not necessarily unpacking, the proper notice, the
Mm-hmm.
unconscionability, and all the nuanced, substantive and procedural parts of the
Mm-hmm.
law. But what would you say to somebody who just feels they're in that situation and their gut is telling them that something is wrong?
Mm-hmm. Well, keep a record of what's been going on. So we like to see paperwork is always really helpful. So if you have conversations, text conversations about a rent increase with a
Mhm.
lawyer or with a landlord, if you have paperwork that you got from your landlord, keep it. Make sure you keep all of the copies of those things, any notices that you get. Record conversation, not record like video recording, but write down when you had
Yeah,
conversations.
yeah, transcribe, like,
Yeah.
yeah, yeah.
And I've been harping on it. It's, there are legal services that are accessible to people.
Mhm,
So consult with them and call them. Don't be afraid to do that because every situation is going to be different. You don't have to be going to court
mhm,
to work with a legal services attorney
mhm.
or any attorney really. So, definitely seek that out if you can. The LSNJ manual is really great.
I mean, this has
It
been
is,
my roadmap through all of this,
and
and
frankly,
it's
I look
excellent.
at I use this. I also do too,
Yeah,
because
it's fantastic.
it's a really concise information. So those are the things that I would say, but definitely don't hesitate to reach out to a legal services provider, CHLP, Northwest, wherever you may be. There is a legal aid and one of our statewide organizations, so
Great.
offices. So yeah.
Great, excellent. So that rounds it out. And Dawn always puts
Oh,
these lovely quotes in there. The sun at home warms better than the sun elsewhere, and I think that is absolutely true, and that's
oh.
lovely. And again, that's part of why we do this because again, it is so important. Your home is your space, and that's where you deserve, to be. And that is part of our mission statement here. Everyone
Mhm.
deserves a home. And you need to do what you can to assert your rights to stay in that home. And that is part of this series for our tenants to make sure that they are apprised of those rights, landlords, so that they can help observe and honor the rights of their tenants.
Mhm.
And then, of course, for anybody else who just wants to know this information and be part of having a community that is just better understanding and better equipped with landlord tenant law and information. So, Sarah, I want to thank you for your time spent
Yeah.
with us. This has been absolutely excellent. I'm going to just briefly check and see if
Any
we have any
questions?
questions. Oh,
Oh,
so it's just, oh no, is the feed?
comment.
Oh no, oh geez. So it looks like it's maybe that it broke up again. Maybe,
Oh
and I think that
no.
might have been Lindsay. So Lindsay's one of my coworkers as well as
Okay.
is Leah. So that their questions are invalid. But I think the thing is that I fixed it before, and I think the video was working. Maybe the slides weren't, working. We described some of the slides, but I think that might have been Lindsay, or at least maybe Tori, who had told me, that it was working. So maybe it's working for some people, maybe not working for others. Maybe you can see us now.
Just blame the internet.
Exactly, exactly. It has nothing to do with my lack of competence and tech capabilities.
Definitely.
So again, Sarah, really a lovely conversation.
Yes.
Thank
Thanks
you
for
so
having
much
me.
for coming out here and spending your evening with us.
Yes.
You came all the way from Elizabeth. So again, I just so tremendously grateful, and for the wonderful information that you
Of
provide to
course.
our audience. We're so grateful.
Yeah,
So,
thanks for having us.
yeah.
It was really great to be a part of this. It's a really great forum. So I loved educating people about their rights. So, and thanks for having us out here.
Absolutely, absolutely. Thank you.
Cool.
Thank you very much. Okay. And thank you to the New Jersey State Bar Foundation once again for allowing us this platform to reach this audience and reach the community and provide them with this vital information. So thank you once again, guys, for joining me and of course, Sarah this evening for STEPP, Stabilizing Tenancy Eviction Prevention Program. Again, next week, the 8th, we are doing habitability.
Woo.
Lovely. So that's going to be a very in-depth
Yeah.
conversation. There's a lot to cover there. And I believe Randy Yang is going to be joining us from Legal Services of Northwest Jersey. And then tomorrow morning, we are going to have the eviction process for tenants. That's going to be a pre-recorded video followed by a live Q&A by yours truly. So please feel welcome to attend that as well. And hope you're all looking forward to it as much as I am. So thanks again for joining us. Have a wonderful evening and take care. We'll see you soon. Bye. And